A Treatise on the Law of Notice by William P. Wade. Chapter 2, Notice to Purchasers. 5 parts. 1. Difference in effect of notice to purchasers of different kinds of property or securities. 2. Registration of instruments. 3. Notice by possession. 4. Notice from title papers. 5. List pendants. Part 1. Difference in effect of notice to purchasers of different kinds of property or securities. Sections. Division of subject, purchasers of real property, purchaser mala fide, notice of marriage settlement, parole contract to convey, when vendee required to perform in lieu of vendor, notice of adopted son's equity, prior and subsequent contracts to convey, possession of title deeds, purchaser with knowledge of trust, mortgagee with knowledge of trust, notice to trustee, notice prior to payment, purchaser without from purchaser with notice, purchaser with from purchaser without notice, repurchase by original mala fide purchaser, unregistered conveyances, how purchasers may be notified, same, purchasers of chattels, innocent pledgees, mere possession not conclusive evidence of title. Secret instructions to broker, secret lien, conditional sales, pledge, condition may be by parole, property reclaimed in an altered state, caveat emptor, chattel mortgages, possession of chattels, choses in action, negotiable instruments, lost bill, holder affected only when grossly negligent, bad faith requisite to defeat holder's rights, purchaser without notice protected, same, knowledge of question of fact, facts which excite inquiry held inadmissible, circumstances which put purchaser on his guard, bad faith and inference of fact, stolen securities, avoidance of knowledge, inquiry excited by inspection of paper, when general notice sufficient, suspicious circumstances, payment before and after notice, patent defects affecting purchaser. Section 48. Division of subject. It is a well-recognized rule of equity jurisprudence that a purchaser with notice of a right in another is liable in the same manner and to the same extent to the person in whom is the right of which he had notice, as was the one from whom he purchased. And this liability attaches in favor of such person, whether he has united in united in himself both the legal and equitable titles, or is merely the owner of an equitable interest with the legal title in the vendor. It applies to all classes of property, whether it be real, personal, or mixed, in possession or in action. It is the purpose in this place to show when and how it applies to these different kinds of property, which for convenience will be considered in the following order: real property, chattels in possession, things in action with special reference to negotiable instruments. Section 49. Purchasers of real property. Except where the statute otherwise provides, a purchaser of real property will be affected by notice, either actual or constructive, of an interest or title adverse to that of his grantor. Notice which is constructively given by the registration of instruments affecting the title is perhaps the most general, but as this portion of the subject is more fully treated in the next part of this chapter, it will not receive further attention here. Section 50. Purchaser mala fide. The general ground upon which courts of equity interfere for the protection of the owner of an equitable interest in real estate as against a subsequent purchaser with notice is that it is in bad faith for one to attempt the circumvention of the true owner of the property by endeavoring to anticipate him in gaining the advantage to be derived from an acquisition of the legal title. Lord Hardwicke, in a leading case upon the subject, which has been so frequently cited as to become familiar to the profession, declares the substance of the rule in saying that The taking of a legal estate after notice of a prior right makes a person a mala fide purchaser, and this principle is applied to that case by the learned chancellor, notwithstanding the fact that the purchase declared to be fraudulent was for a valuable consideration, and the notice by which the purchaser was affected was given to an agent, and there was no evidence that it had been communicated to the principal. Section 51. Notice of marriage settlement. Upon this principle, where the defendant purchased an estate with notice of the fact that it had been previously entailed to the plaintiff in a marriage settlement by his father, who was defendant's grantor, it was held that such purchaser took the estate charged with the trust which the court would compel him to execute by, by accounting for the consideration received upon transferring the property to innocent purchasers. Section 52. Parole contract to convey. So a purchaser with notice of a parole contract executed on the part of one of the parties between the owner of the fee under whom he claimed and a tenant per autre va to change the cesta kv by inserting the name of the tenant's wife instead of an older life uh, was held by decree to specific performance of the contract. Section 53. When vendee required to perform in lieu of vendor. There are also numerous cases where the owner of the equity has gone into possession of the real estate under a parole contract of purchase, which only becomes the subject of equitable enforcement by reason of the fact that there is a part performance by the covenantee, which takes it out of the operation of the statute of frauds. In these cases, the purchasers who took with notice of the facts were decreed to perform precisely as though they were the original contracting parties. Section 54. Notice of adopted son's equity. And even where the claimant's equity is not fortified by possession and improvement, there are cases of a peculiar character where the courts have granted relief against the purchaser with notice, as where an agreement was entered into with the father of an infant son by an uncle to adopt the nephew as his own child, with provision that his property should descend to such adopted son on the death of the uncle and wife. Pursuant to this agreement, the child was taken into the uncle's family and lived with him until he reached the age of 25. At the age of 65, the uncle, in consideration of the support of himself and wife for the remainder of their lives, conveyed a considerable portion of his property to his wife's sister. The grantee, taking the deed with notice of the nephew's equity, was held not to be a bona fide purchaser, and the nephew was entitled to relief. Section 55. Prior and subsequent contracts to convey. As between antecedent covenantees and subsequent covenantees with notice, the first contract will be enforced. The prior equity is entitled to the same protection against subsequent purchasers in bad faith as though the contest lay between rival claimants to the legal title. So where one contracted with two different parties to sell the same estate, the one first in time would be entitled to specific performance, and the subsequent covenantee, having obtained the legal title after notice of the prior equity, was decreed to convey to the first covenantee. Section 56. Possession of title deeds. It has been held in England, where the possession of the title deeds usually accompanies the title, that notice that such deeds were in possession of another than the grantor was sufficient notice of an equitable claim by the holder of the deeds to bind the property in the hands of the purchaser. Especially is this so held where, with notice of such possession, there is an entire absence of inquiry with regard to the causes for the absence of the title deeds from the possession of the grantor. But when it appears that the purchaser has been reasonably diligent in the prosecution of his inquiries as to the reasons for the possession of the title deeds by one other than the grantor, and a reasonable and satisfactory excuse has been made for the circumstance, this will remove the imputation of fraud or gross negligence, upon which the presumption of notice is founded. Section 57. Purchaser with knowledge of trust, which where one with knowledge of a trust, or notice thereof sufficient in equity to affect his conscience, purchaser purchases from the trustee, the property so purchased will still be subject to the trust, and he will be held to be a trustee for the benefit of the person whose rights he has thus sought to defeat. Section 58. Mortgagee with knowledge of trust. Upon the same principle, if a mortgagee with notice of a trust should obtain a conveyance from the trustee in order to protect his mortgage, the original trust would attach to the title in his hands, and he would not be permitted to reap any advantage by such a conveyance. By the purchase, he would take the place of such trustee with reference to the title, and it would be his duty to execute the trust. To allow him to enjoy an advantage from such a transaction would be equivalent to permitting him, in order to save himself, to commit a breach of trust. Section 59. Notice to trustee. A trustee is chargeable with notice of the equities arising from the trust, and being a member of a firm, notice coming to him in this manner will affect his partners in the same manner and to the same extent as though they had been personally notified, for the court will not regard the character in which the notice was received. Section 60. Notice prior to payment. In order to affect purchasers, it is not always necessary that the notice should be actually received before the execution and delivery of the conveyance. It will be sufficient if given before the payment of the purchased money, and when there has been a partial payment before notice received, the purchaser will be affected pro tanto. Section 61. Purchaser without from purchaser with notice. Where a purchaser acquires a title with notice, actual or constructive, of an adverse title or interest in another, although as between himself and the equitable owner he holds the title charged with a trust in favor of the latter, he may be a conveyance to a bona fide purchaser for value, who has no notice of the trusts with which the property stands charged, effectually cut off the rights of the equitable claimant for the purchaser without notice from a purchaser who took with notice will occupy no worse position than one who innocently purchases from the first fraudulent grantor. Section 62. Purchaser with from purchaser without notice. So where the bona fide purchaser conveys to another who has notice of the equity at the time of his purchase, the title will nevertheless pass discharged of the trust to which it was subsequent no to which it was subject in the hands of the first grantor. For to merely protect the title of the first purchaser without notice, and hold the property subject to prior equities whenever it subsequently came to the hands of one who had notice of such equity, would be to give the honest purchaser but a fruitless advantage. Such a rule would deprive the property of nearly its entire market value, because purchasers without notice would become more difficult to find as the defect of title became more generally known. Section 63. Repurchase by original mala fide purchaser. The same reasons will not operate in favor of the original purchaser mala fide when he reacquires the title after it has passed through the hands of bona fide purchasers, by holding that the trust would rather by holding that the trust would reattach in his hands, but a single possible purchaser is disqualified which could not materially affect the market value of the property. Besides, to extend to him protection as an innocent purchaser because of the purgation of the title by passing through the clean hands would be to facilitate the perpetuation of fraud. Section 64. Unregistered conveyances. Notwithstanding the statutory provisions by which the registration of conveyances is required in order to give them validity as against subsequent purchasers, these statutes are uniformly construed not to favor those whose who purchase with notice of prior unregistered conveyances. To hold otherwise would be to convert the registry laws, which were originally intended as a protection against fraud, into the most formidable accessories of fraud. Section 65. How purchasers may be notified. The methods by which notice of prior equities or unregistered conveyances may be given so as to affect subsequent purchasers are as various as the means by which knowledge or information of any fact may be communicated, or by which persons may be led to believe in the existence of such facts. They include those facts and circumstances which are held to constitute constructive notice, as well as those amounting in the estimation of the court or jury to actual notice, and affect subsequent purchasers and encumbrances alike. The most obvious and direct manner in which the subsequent party may be warned of the adverse interest is by actual knowledge of the prior conveyance or equity. For in determining questions of good faith, knowledge is regarded as equivalent to notice of the highest degree, though it may be otherwise when notice is requisite to perfect a right, or to put the person to whom it is given in default. Then would naturally follow in their order express notice, or direct information, oral or written, from some person in possession of actual knowledge, and implied notice or knowledge of collateral circumstances sufficient to put the purchaser or encumbrancer upon inquiry leading to the truth. And lastly, such facts as would raise a conclusive presumption of law that the party charged with notice had received the same. Information from whatever source derived, which would excite apprehension in an ordinary mind and prompt a person of average prudence to make inquiry would be sufficient. Yes, we covered that in ante sections 11 and 27. Okay, section 66, same. Embraced within these different means of notice are adverse possession, which has been considered as actual notice, and in some instances as constructive notice of title or interest. Notice from title papers, which also seems to have been considered as both actual and constructive, and list pendens, which, according to the accepted meaning of the term, is clearly noticed only by the aid of legal presumption. Section 67. Purchasers of chattels. The general doctrine by which purchasers of real estate are affected with notice of prior unregistered instruments affecting the title or of prior equities applies in substantially the same manner and to the same extent to purchasers of chattels in the possession of the vendor at the time of the sale. That is, when the purchase is made bona fide from one who has the legal title or who has been clothed by the owner with all the indicia of ownership or authority to sell, the purchaser would be protected. But if the purchase be made with notice of title or interest in another, or with a knowledge of such circumstances as would suffice to put him upon inquiry leading to actual knowledge of such interest, his purchase would be fraudulent as against the true owner, and he would not be permitted to profit by it. Section 68. Innocent pledgee. The case of Crocker v. Crocker is an illustration of both propositions in the next preceding section. There, the plaintiff being indebted to a corporation on account of unpaid assessments on shares of its stock and being a creditor of the corporation to an amount almost equal to the amount of his unpaid assessments, it was agreed that upon a sale of his stock for what remained unpaid, he was to receive credit for the amount due him and then pay in the balance. In pursuance of this arrangement, defendant, who was plaintiff's brother at the instance and request of plaintiff, attended the sale and bid in the stock, but was only required to pay the amount remaining after the deduction of the amount due plaintiff from the corporation. The legal title was vested in the defendant, who had all the indicia of absolute ownership. But as between himself and brother, he held as trustee for the latter. It was also held that he had no title or interest which he could convey to a purchaser with notice of the trust, so as to divest the beneficial interest of his cestui trust. But where one who had neither actual nor constructive notice of such interest received certain shares of such stock in pledge from the trustee, parting with value therefore, and taking the same in the honest belief that they were the property of such trustee, the innocent party who was thus misled by the fraudulent acts of the trusted agent of the plaintiff was entitled to protection in his possession of the stock. Section 69. Mere possession, not conclusive evidence of title. The case of Worcester v. Sherwood was where the subject of the sale was a quantity of barley in a brewery. The vendor afterwards sold the brewery and contents, giving notice to the purchaser of the specific quantity of barley to which plaintiff was entitled. This passed no title to any portion of plaintiff's barley to the purchaser of the brewery, and a sale and delivery of the same by the latter to an innocent purchaser for value was held equally invalid to divest plaintiff's title for the reason that the vendor had not been clothed by him with any apparent authority to sell or any power to exercise control over the property. Section 70. Secret instructions to broker. It has been elsewhere held that where one purchased goods and chattels and had them transferred to a broker whose business it was to sell such merchandise, and the broker was authorized by the owner to assume the apparent right to dispose of the property in the ordinary course of trade, the secret instructions to the broker would not affect the rights of a purchaser who had no notice of them. Section 71. Secret lien. In Western Transportation Company v. Marshall, the sale was of a quantity of grain, which the court held had been duly delivered by plaintiff on board defendant's ship, accompanied by such written indicia as, together with the possession of the grain, would lead others to believe that the purchaser was the owner. Under these circumstances, it was held that one who purchased without notice of the non-payment of the purchase money, which according to the contract was to be paid on delivery, in the grain having been in the possession of the first purchaser for 4 days, was a bona fide purchaser and within the protection of the law. But the learned judge, in rendering the opinion in this case, goes to the extent of declaring that where the owner voluntarily delivers the possession of merchandise to a vendor, subsequent bona fide purchasers from such vendor, and those incurring liabilities in making advances on the faith of such possession, or standing in the relation of a bona fide purchasers, are entitled to protection against the claims of the former owner, although the sale be conditional and the purchase price not paid. Section 72, conditional sales. While it may be true, as in the case last cited, it seems to have been held that a sale may be absolute, although the terms of payment are not complied with by the purchaser, and that the subsequent vendee, without notice of such noncompliance, will be protected as an innocent purchaser. The doctrine has been established by a long line of decisions that where the sale is conditional in the sense that the property and the chattels is not to pass until the performance of the conditions, the mere surrendering of possession to the conditional vendee will not amount to such apparent authority to dispose of the goods as will enable him to give to a purchaser a title superior to that by which he held. In other words, until the goods are paid for, if that be the condition, they belong to the original owner, and although the purchaser from the conditional vendee take without notice of the absence of title in his vendor, the owner may reclaim the goods. Section 73, Pledge. So where property has been disposed with a person as a pledge to secure the payment of a sum of money in the future, or to answer for the depositor's default in the performance of some other act of pecuniary benefit to the pledgee, the contract between the parties will govern as to the character of the pledgee's possession, and should be he transfer such possession to another and attempt at the same time to transfer the title, his act being in contravention to the terms of the contract would be uh, nugatory, so far as it affected pledger's right to redeem. Although the person to whom the transfer was made had no notice of the owner's claim or title, in this case cited, the pledge was of certificates of shares of stock to which were attached a blank power of attorney authorizing the attorney to sell the stock. Notwithstanding that the pledgee, in violation of the terms of the contract, by filling out the power of attorney, clothed himself with the apparent jus dispondendi, it was held that this did not authorize him to sell without complying with the legal requirements in case of the sale of a pledge, such as notice to and demand of the pledgor, and a sale to an innocent purchaser in fraud of the rights of the pledgor would not divest the title of the latter. Section 74. Condition may be by parole. The case of Clark v. Wells was where a coach had been left with a mechanic for repair, and he supplied new wheels to the vehicle, which were by parole agreement to remain his property until paid for. Before paying for them, however, the owner sold the coach to an innocent purchaser who resold it to another, and although neither had notice of the mechanic's claim to the wheels, it was held that in the absence of evidence showing latches on his part, he might reclaim them from the last purchaser. Section 75. Property reclaimed in an altered state. Another example of the effect given to conditional sales, where uninformed purchasers or creditors would be least likely to suspect the property and the possession to be in different persons, is the case of Barrett v. Pritchard. There, the claimant had sold wool to a manufacturer upon condition that it was to be paid for in 6 months, and until paid for, whether it remained in its original condition, was manufactured, or in process of manufacture into yarn or cloth, it should remain the property of the vendor. This was held to be a valid contract and one which could not be enforced by the conditional vendor by reclamation of the property as against creditors without notice. Section 76. Caveat emptor. While it is not denied that possession of personal property is prima facie evidence of ownership, it is quite evident from the foregoing authorities that except where the statute interposes for the protection of innocent purchasers, such property may be held subject to secret claims, and the title will be transferred subject to the doctrine of caveat emptor. Section 77. Chattel mortgages. The title to personal chattels is only affected by the registry laws when the property is mortgaged or conveyed in trust as security for the discharge of an obligation for the benefit of the mortgagee or beneficiary mentioned in the deed of trust. As respects the registry of chattel mortgages and the effect of such registry as notice to subsequent purchasers and encumbrances, the rules are substantially similar to those recognized where conveyances of real estate are in question. In some of the states, however, there is a difference in the effect of the registry of instruments affecting the titles to these different kinds of property in this that unregistered chattel mortgages are absolutely void, even as against subsequent purchasers or creditors with actual notice thereof. They differ from conveyances or encumbrances of real estate, for the reason that their validity depends as much upon their proper acknowledgement and registration as upon their execution and delivery. Section 78. Possession of chattels. What is elsewhere said concerning the doctrine of notice of prior claims to real estate, which comes from knowledge or information of the possession of the property by the adverse claimant, will apply with still greater force so far as it favors such doctrine to the possession of personal chattels. Section 79. Choses in action. Choses in action, which in equity according to the law merchant or under the favoring provisions of statute law are assignable, occupy a position with reference to the question of notice, essentially different from that occupied by any other species of property, when the subject of the transfer is not negotiable according to the law merchant, the equities subsisting against it in the hands of the assigner follow it into the hands of the assignee, whether he has notice of such equities or not. Where the transfer of a negotiable security involves nothing further than a mere change of title, the purchaser is at once subrogated to all the rights and assumes all the liabilities attendant upon the ownership of the assignment. But chattel mortgages will only be declared void as against subsequent purchasers for value. The provision of the statute requiring such instruments to be recorded in order to give them priority over the claims of subsequent purchasers is not intended for the benefit of those who have paid nothing. The effect of recording a chattel mortgage as notice to purchasers will follow the chattels when removed to another state. Section 80. Negotiable instruments. But respecting negotiable instruments and their transfer, the purchaser occupies a more advantageous position than the purchaser of any other species of property. It is true that even he will be affected by notice of equities which would have defeated the security in whole or in part in the hands of the original payee. But so favorable is the law to the facile transfer of negotiable paper that it will not suffer its assignability to be obstructed by a mere technical notice to the purchaser that the obligor is between himself and the obligee has a defense to the demand. The notice of defenses to negotiable paper to affect purchasers must therefore be actual and not merely constructive, and must be of a higher degree than circumstances sufficient to put a man of ordinary prudence on inquiry. Section 81, Lost Bill. The doctrine laid down in the preceding section was substantially announced by Lord Kenyon in the early case of Lawson v. Weston, where the question arose upon a lost bill which had been discounted without actual notice of the rights of the original payee. It was sought to charge him with notice by proof that the loss was advertised and payment stopped by notice to the drawee. As the bill came to the possession of the holder who had discounted it without fraud on his part, the advertisement was held not sufficient to bind him. The earlier case of Miller v. Race is cited in support of the same principle, but as that was decided with reference to a bank bill which circulated as cash, it could have no application in considering the question of notice as it affects commercial paper. Section 82. Holder affected only when grossly negligent. This doctrine was shaken for a time in England by a case in which it was decided that where one discounted a bill which had been advertised as lost, in the ordinary course of his business, under circumstances which ought to have excited the suspicions of a prudent man, he was not entitled to recover against the endorser. But in a subsequent case, this uncertain and vague test was expressly repudiated with the concurrence of all the judges of the Court of King's Bench, and it was held incumbent upon the drawer of an accommodation bill upon which suit was brought by the endorsee in order to avail himself of the defense that the bill was fraudulently put in circulation to show that the holder had been guilty of gross negligence. This case was affirmed at the same term, where the case of Gill v. Cubitt and others adhering to the doctrine there announced was expressly overruled. Section 83. Bad faith requisite to defeat holders' rights. In a still latter case before the same court, the question of gross negligence was held proper for submission to the injury in a suit between the endorser for value of a bill of exchange and a prior party thereto, but it was given as the opinion of the court that this alone would not be a sufficient answer where the holder had given value for the bill. Bad faith on the part of the purchaser was regarded as an essential fact to be established by the defendant, and though gross negligence might be evidence of such bad faith, it did not amount to the same thing. Subsequent English decisions have reaffirmed this doctrine, and it is now regarded as the settled law of England. Section 84. Purchaser without notice protected. In Swift v. Tyson, the question of notice was not fairly at issue, but it was there laid down by Mr. Justice Story as a general rule that a purchaser of negotiable paper in the ordinary course of business and for valuable consideration without notice of facts which would impeach its validity between the antecedent parties, if he took it under an endorsement made before the same became due, held the title unaffected by these facts, and might recover thereon, although, as between the original parties, the transaction was without legal validity. This doctrine was there declared by the learned judge to be so long as and so well established and so essential to the security of negotiable paper that it had been laid up among the fundamentals of the law and no longer required argument or the citation of authority in its support. Section 85. Same knowledge, a question of fact. In citing the above case and making copious quotations from the opinion of the learned judge, Mr. Justice Clifford, in Goodman v. Simmons, interprets the word notice as there employed to be the same as knowledge, and deduces therefrom the rule that nothing less than proof of knowledge of such facts and circumstances can meet the exigencies of such a defense. And the question whether the party had such knowledge or not is a question of fact for the jury. And the proper inquiry is, did the party seeking to enforce the payment have knowledge at the time of the transfer of the facts and circumstances which impeach the title, as between the antecedent parties to the instrument? And if the jury find that he did not, then he is entitled to recover unless the transaction was attended by bad faith, even though the instrument had been lost or stolen. Section 86. Facts which excite inquiry held inadmissible. In Woolfolk v. Bank of America, Judge Pryor, in rendering the opinion of the court, says, in a case like this, the defense must allege and prove a knowledge of the facts constituting the fraud on the part of the holder. That is, such facts as would satisfy one of ordinary prudence and judgment of the infirmity in the bill, and the evidence of such facts and circumstances on the part of the holder as would lead to any inquiry, by which only the facts constituting the fraud might be ascertained, is clearly inadmissible. The question of negligence, whether gross or otherwise, or diligence on the part of the purchaser, is here allowed to have no influence whatever, even as a fact or circumstance by which a participation in the fraudulent inception or circulation of the instrument might be established or disproved. Section 87. Circumstances which put purchaser on his guard. In Cone v. Baldwin, which was an action by the purchasers of a negotiable note against the maker, it is conceded that the defendant was not bound to prove that the plaintiff's purchased with full and certain knowledge of the want or failure of consideration, but that if the circumstances attending the transfer were such as to put them upon their guard, they were bound to make inquiry, and that if they did not, they purchased at their peril. Nevertheless, it was held in that case that the mere statement of the payee in transferring the note by delivery to the plaintiffs that they purchased at their own risk was not a circumstance rendering it incumbent upon them to inquire into the consideration. The point conceded in this case may hardly be taken as a contradiction of the doctrine laid down in the cases previously cited, though the principle upon which those cases were determined has not passed unchallenged in this country. It has not, however, met with sufficient opposition to change the current of authority which is borne constantly in a direction favorable to purchasers of negotiable paper. One of the latest and best considered cases upon the subject presents the unusual feature of an entire change of view by the same court, not only with respect to a case involving the same question, but in deciding the same case. The judgment of the trial court had been reversed and the cause remanded, and the case went up the second time with instructions given in accordance with the former ruling of the appellate court. The first decision of reversal was expressly overruled and the judgment again reversed. Judge Wagner, in rendering the opinion in this case, makes an able review of all the most important cases, both English and American, and justifies the departure of the court from the former ruling in the same case upon principle as well as authority, there having been several cases decided subsequent to the first hearing in Hamilton v. Marks, where a doctrine was announced inconsistent with that under review, although the case was not expressly overruled. The conclusion reached by the learned judge is certainly in harmony with the views expressed by the courts of last resort of the principal states of the Union, as well as the Supreme Court of the United States. Knowledge of the infirmities of a bill or note coming to one of two partners in a private bank will be imputed to the partnership so that the bank cannot be a bona fide holder of such paper. Section 88, Bad Faith and Inference of Fact. There seems to be a peculiarity common to nearly all the cases in which this question of notice is raised. The inference of notice which is sought to be drawn from circumstances sufficient to put a prudent man upon inquiry is one of law and not of fact. The only question submitted to the jury by the objectionable instructions is whether there existed such circumstances, and from these, if found, the court is asked to instruct the jury that the legal inference of notice follows. It is frequently asserted, in those cases requiring actual notice of the facts urged by the maker or drawer of negotiable paper, that the question of knowledge or notice is one of fact, and it is difficult to imagine as an issuable fact which is not susceptible of proof by the evidence of circumstances. It may therefore be fairly deduced from the authorities that whatever is sufficient to satisfy the jury that the purchaser took the security in bad faith, or that he was willfully blind to the circumstances impeaching its validity, will warrant the inference that he had actual notice of the facts. This rule does not involve the vagueness and uncertainty of the doctrine so often insisted upon, and as we have been so generally repudiated, that the purchaser of negotiable securities is to be charged with notice of their latent infirmities merely by the existence of circumstances sufficient in the opinion of the jury to put a man of ordinary prudence upon inquiry. Pagwood v. Gridley. In this connection, the case of Cass County v. Green, decided at the October term 1877 of the Superior Court of Missouri and announced on the 16th day of February 1878, is a noteworthy example. This was a proceeding by injunction to prevent the negotiation of certain fraudulently issued bonds in the hands of defendant who claimed to be an innocent purchaser for value before maturity. The court, in affirming the decree enjoining the transfer of the bonds, based its judgment upon the ground that defendant had actual notice of the infirmities of the bonds, though there was no evidence of such actual notice other than the inferences to be drawn from the conduct of defendant and his opportunities for arriving at a knowledge of the facts. Defendant was not the first purchaser sought to shelter himself under the absence of notice, both to himself and to the first purchaser. But the facts and circumstances from which notice to the defendant was inferred pointed with an even more unmistakable directness to the first purchaser as having notice of the fraud by which the securities were tainted. The bonds were first purchased from one of the persons originally concerned in their fraudulent issue by a banking partnership, and the notice imputed to the firm was shown by purely circumstantial evidence to have been communicated to one of its members. The decision in this case was held not to be in conflict with the adjudication of the same question last theretofore made by the same court, where it was held in substance that facts and circumstances coming to the knowledge of a purchaser for value of negotiable paper sufficient to put a man of ordinary prudence upon inquiry, would not suffice to affect the paper in his hands if purchased before maturity. Though the facts and circumstances relied on in this case were such as would tend to put a purchaser upon inquiry, and the defendant testified to his want of knowledge prior to his purchase, the inference drawn from the circumstances was that, as a matter of fact, he had received notice when he made the purchase of the bonds. To prove notice or knowledge in a case of this kind does not require evidence of a higher character than what would be sufficient to establish any other disputed fact. In transactions of this kind, where the onus of showing good faith is cast upon the purchaser of negotiable paper, it will not be sufficient for him to show that he did not know of the infirmities of the paper. So, as so long as it appears that he believed in their existence, and the fact of such belief might readily be inferred from evidence that he had reason so to believe. Section 89, Stolen Securities. Avoidance of knowledge. In one of the latter cases, where this question was examined by the Commission of Appeals of the State of New York, in commenting upon the error of the trial court in excluding evidence which it was alleged tended to prove good faith on the part of the purchaser, undue weight seems to have been given to what might be, in cases disclosing parallel facts, a willful avoidance of the knowledge which, if communicated, would have rendered the purchase an act of bad faith. There, printed notices of the larceny of certain negotiable securities were left at the place of business of the corporation sought to be charged prior to their purchase of the stolen securities, and one of the excuses deemed admissible in evidence for their utter disregard of such notices was that the exigencies of their business were such, their dealings in such securities so extensive, that the time could not be spared to read and record the large number of such notices left at their place of business, warning them of the stealing of similar securities. The exigencies of one's own business, when adopted by him as an absolute standard by which his duty to others is to be measured, seems fraught with danger to all honest people except the one who adopts it. A banking institution in the city of New York, understood to be dealing so largely in negotiable securities that its officers were justified in ignoring all warnings with respect to stolen securities, would be able to offer absolute security to thieves. Section 90. Inquiry excited by inspection of paper. The principle upon which knowledge or information of facts merely sufficient to put the party upon inquiry may be ignored has no application where the knowledge is derived from an inspection of the instrument itself, and points directly to a defect which requires explanation from the holder. Neither does it apply where the inquiry excited by circumstances may be prosecuted to knowledge. Prosecuted, yep, by an inspection of the instrument. As where the purchaser has knowledge of facts showing that certain securities have been lost by the holder, or that he has been fraudulently deprived of the possession thereof, and the facts of which he has knowledge include a description of the lost instruments by numbers or other distinguishing marks, here inquiry may be said to be necessary in order to identify an instrument of the general character of those lost or stolen, which may be offered him as one of the missing securities. The inquiry, however, need extend no further than the face of the instrument, but if it falls short of this, he purchases at his peril. Section 91. When general notice sufficient. In Kraft's appeal, two kinds of notice are recognized as sufficient to affect purchasers of negotiable paper transferred before due. These are styled particular or explicit, and general or implied, corresponding substantially to our classification of express or implied, and it is there held that a willful or fraudulent failure to inquire into circumstances known to be such as to invite inquiry would warrant the jury, if they believed from the evidence that such abstinence was from the belief that the inquiry would result in finding that the note was invalid, in regarding it as a case of general notice. And though mere negligence, however gross it may be, is not regarded as amounting to willful or fraudulent blindness, it is mentioned as proper for submission to the jury in connection with other circumstances tending to prove such general notice. But if, notwithstanding the absence of such caution and prudence in making the purchase as should be exercised in the ordinary affairs of life, the transaction was honest on the part of the purchaser and in the regular course of his business, he will hold the paper discharged of prior equities. Section 92. Suspicious circumstances. But the circumstances by which it is sought to prove that a purchaser of negotiable paper took with knowledge of equities between the original parties must be of a character in themselves suspicious. The inquiry excited must have reference to some matter affecting the validity of the instrument. It will not be sufficient that the circumstances attending the transaction, or even the memoranda on the paper itself, are unusual or extraordinary, unless they direct attention to some infirmity of the instrument. It will be safe for the endorser to disregard them. Accordingly, where a note contained the memorandum secured by mortgage, this was held not sufficient to put a purchaser upon inquiry, nor charge him with notice of the contents of such mortgage, and the mere fact that the mortgagee mentioned in the mortgage by which the note was secured was a different person from the payee of the note was held insufficient to make it the duty of the purchaser to inquire as to the validity of the note. Section 93. Payment before and after notice. The protection afforded to purchasers of negotiable instruments before maturity is intended to benefit those who have not only acted in good faith and without notice of the infirmities affecting the instrument in the hands of the original payee, but have paid value therefor. One who has paid nothing prior to notice would not be protected in his purchase, and if a partial payment is made, the protection will only extend to the amount actually paid prior to notice, and as to that paid subsequently, he will be treated as a purchaser mala fide. Section 94. Patent defects affecting purchasers. Cases are frequently cited in support of the application to negotiable instruments of the doctrine of implied notice, which upon examination appear to be inapplicable for the reason that the matters therein set up in defense and which are supposed to challenge inquiry are apparent on the face of the instrument, and if unexplained utterly destroy their negotiability. An order bill payable to bearer or to the order of the payee therein named, after it has been dishonored, can no more be protected in the hands of a subsequent purchaser as negotiable paper transferred before maturity than though it had never contained words of negotiability. Therefore, if such an instrument appears on its face to have been dishonored by non payment or non acceptance, it drops out of its place as a negotiable instrument protected by the law merchant, and so far from its being necessary to bring the knowledge of its latent defects home to the purchaser in order to charge him, he is bound by the equities subsisting between the original parties without any notice at all. Part 2 of Chapter 2. Let's see.